two-lane road in Lago Vista, Texas. Afternoon light. A pickup truck rolls along at a careful speed, a mother at the wheel, her two small children in the cab beside her. None of them is wearing a seatbelt. That is all. No weaving, no speeding, no danger to anyone on that road. Just three people in a truck with the belts unbuckled. A patrol car pulls in behind her. The officer walks up and he is not reaching for a ticket book. He is reaching for his handcuffs. Within minutes, this mother is pulled from her own truck, her hands cuffed behind her back, and driven away while her frightened children are left at the roadside. Her offense carries no jail time. It cannot. The most the law can ever do to her is take $50. So ask it about your own car and your own afternoon. For something the law says is worth nothing but a small fine, can the police put you in handcuffs and take you to jail? This is Lago Vista, a small town on the edge of a lake north of Austin, and the woman in the truck is named Gail Atwater. What happened to her that afternoon is not a story about a bad law being broken by a rogue officer. The law was on the officer's side. That is exactly what makes it worth your time. Because most of us carry a quiet assumption around. You assume a punishment has to fit the offense. You assume that if the worst the state can do to you is fine you a few dollars, then a few dollars is all that is really at stake. You assume no one gets handcuffed and booked into a cell over a seatbelt. The Supreme Court of the United States looked hard at that assumption. And in the year 2001, by a single vote, it told you that you were wrong. This is the story of how a $50 seatbelt ticket climbed all the way to the highest court in the country, and what the justices there decided the police are allowed to do to you. This is prime documentary. Start with the day itself. In 1997, Gail Atwater was driving her pickup through Lago Vista with her two young children in the front seat. The belts were off. A local police officer named Bart Turek saw it and he pulled her over. This was not their first meeting. Turek had stopped Atwater once before over a seatbelt, and that time he had been wrong. This time he was right. But being right about a seatbelt does not usually end this way. By her account, he came up shouting, pointing his finger, telling her she was going to jail, and he said it in front of her children. She asked to take her frightened kids to a friend's house nearby first. He told her she was not going anywhere. Then he arrested her. He cuffed her hands behind her back. He put her in the back of his squad car. A neighbor came out and took the two children inside, so they would not have to watch the rest. Turek drove Atwater to the police station. There she was made to take off her shoes, empty her pockets, and hand over everything she was carrying. They took her photograph, the booking picture. They put her in a holding cell alone and left her there for about an hour. Then she was brought before a magistrate and released on bond. For what? Not for hurting anyone. Not for a threat or a theft or a single reckless act behind the wheel. For a seatbelt. Texas law made driving unbelted and letting your children ride unbelted a misdemeanor. And the punishment the law set for it was a fine. A small one. No less than $25, no more than $50. No matter what any court later decided, Gail Atwater was never going to serve a single hour of jail as her sentence. She later pleaded no contest to the seatbelt offense and paid the fine. $50. That was the entire penalty the law had ever attached to what she did. The handcuffs, the squad car, the cell, the booking photo, none of that was her punishment. It happened before anyone had decided she was guilty of anything at all. Gail Atwater did not let it go. She and her husband sued the city of Lago Vista, its police department, and Officer Turek. They used a federal law, the one that lets an ordinary person take a government official to court for breaking the Constitution. Their claim was about the Fourth Amendment. You know the Fourth Amendment even if you have never read it. It is the one that protects you against unreasonable searches and seizures. An arrest is a seizure. It is the state laying hands on your body and taking away your freedom. And the single word the amendment uses to judge all of this is reasonable. A seizure is allowed if it is reasonable and forbidden if it is not. So Atwater's argument was simple, and it probably sounds right to you. A full arrest, she said, is a heavy thing. Handcuffs, a squad car, a cell, a booking? For a crime that the law itself says is not worth a single day in jail, that heavy thing is too much. It is not reasonable to haul someone to a cell over an offense whose entire penalty is money. Where the only punishment is a fine, she argued, the police should write a citation and let you drive on unless they have a real reason to do more. Notice what she was not saying. She was not saying the officer got the seatbelt wrong or that he lacked a reason to stop her. Everyone agreed he had probable cause. She was saying that probable cause for a tiny offense should not be enough, all by itself, to justify the full weight of a custodial arrest. That there had to be a line somewhere, and that hauling a mother to a cell over $50 fell on the wrong side of it. The city's answer was just as simple. The officer had probable cause to believe she broke the law right in front of him. That, the city said, is the whole test. When an officer watches you commit an offense, any offense, he may arrest you. How small the crime is does not change the rule. Two clean arguments pointing in opposite directions. And the question underneath them touches every driver and pedestrian the police might ever have a lawful reason to stop. When the offense is trivial, does the Fourth Amendment force the police to simply write you a ticket and let you go? The case reached the Supreme Court, and in April of 2001, the court gave its answer. It sided with the city. By a vote of 5-4, the court held that the arrest of Gail Atwater did not violate the Fourth Amendment. Read that slowly because it is the whole point, and it is easy to get backwards. The court did not say the officer had to arrest her. It said he was allowed to. The handcuffs, the squad car, the cell, the booking photo, all of it, for a fine-only seatbelt offense was constitutional. The police could do this. The Fourth Amendment did not stop them. Justice David Souter wrote for the majority. His reasoning ran on history. He looked back at the centuries of law the country inherited, the old rules the framers would have known, and he found no firm tradition forbidding an officer from making a warrantless arrest for a minor offense he watched happen. If there was no clear historical ban, Souter reasoned, the court should not invent one now. And he gave a practical reason too. A rule that let arrests turn on how serious the offense was would force officers to make fine legal judgments in a split second at the roadside, guessing whether a given crime carried jail or only a fine, and getting sued if they guessed wrong. A clear rule, arrest allowed wherever there is probable cause, is easier to apply and harder to abuse than a rule that asks every officer to weigh the penalty first. Here is the part that matters most. Souter did not pretend that what happened to Gail Atwater was good. He described her arrest, in the court's own words, as a pointless indignity. He agreed it was gratuitous and humiliating. He came close to saying that if he were writing the rule for her case alone, she might well win. But a single sympathetic case, he wrote, is not enough to bend the Fourth Amendment into a standard that judges every arrest one by one. The fix for pointless arrests, the majority said, belongs to the people who write the laws. Legislatures can forbid these arrests, and many states have. The Constitution simply does not. 4 justices could not accept that. Justice Sandra Day O'Connor wrote the dissent, joined by 3 of her colleagues. She agreed the officer had probable cause. But probable cause, she argued, was never meant to be the end of the question. The Fourth Amendment asks whether a seizure is reasonable, and reasonableness has to weigh what the state gains against what the citizen loses. A full custodial arrest is one of the heaviest things the government can do to a free person on the street. Set that against an offense that cannot send anyone to jail, and the balance, the dissent said, tips the other way. For a fine-only crime, an officer should issue a citation unless he can point to specific facts that justify doing more. And O'Connor named exactly what she believed the majority had done. Speaking for the dissent, she wrote that the court neglects the Fourth Amendment's express command in the name of administrative ease. In so doing, it cloaks the pointless indignity that Gail Atwater suffered with the mantle of reasonableness. But the dissent is the side that lost. 4 votes, not 5. So go back to the question from the road. For something worth nothing but a $50 fine, can the police handcuff you and take you to jail? After the spring of 2001, the answer from the highest court in the country is yes. Not that they must, that they may. This is the uncomfortable shape of it. Gail Atwater lost. The officer who cuffed a mother in front of her children over a seatbelt was found to have broken no constitutional rule at all. The thing that unsettles you about her afternoon is not that it was illegal. It is that it was allowed. And that is a different kind of unsettling. A rule you can point to and call unconstitutional at least gives you somewhere to go. What the court handed down here is the opposite. It looked at the full weight of an arrest laid on top of the smallest possible offense, called it a pointless indignity out loud, and then said the Constitution permits it anyway. The wrong, if you feel one, is real. The remedy the majority left you is not a court. It is a legislature, which means the protection you might have assumed was written into the Fourth Amendment is, across much of the country, only as strong as whatever your state has put into a statute. Some states have passed laws telling their officers to write the ticket and let minor offenders drive away. Where those laws exist, you are covered by them, not by the Constitution. Where they do not, the rule of Atwater still stands. An officer who sees you break even the smallest law can, if he decides to, put you in handcuffs. Gail Atwater buckled up and paid her $50 a long time ago. What she left behind is a line the Supreme Court drew and has not erased. The next time someone tells you a rule is too small to matter, remember the mother in the pickup, and remember what the justices decided a small rule can still cost you. If you would rather learn where the edges of your rights actually are before the afternoon you need them, stay with us. At Prime Documentary, we read the fine print of the Constitution out loud, one case at a time.